Welcome again. We are IKP Knowledge Park and IKP EDEN. We are probably the largest chain of startup incubation centers across India with 9 incubation programs running across the country. Today we have Anantram Ganesh from Economic Laws Practice. They are a Mumbai-based firm, and Anantram has recently moved to Bangalore to start the Bangalore chapter of ELP. Anantram is a lawyer by profession. Ms. Dipanvita Chattopadhyay has been chairman and CEO of IKP Knowledge Park. IKP is a 20-year-old science park and startup incubator. I am Vikraman. I manage IKP EDEN in Bangalore, which is our hardware product incubation center. IKP over the last 20 years has supported over 600 companies, 350 of them through funding programs and the rest of them through infrastructure support programs. We are located in Hyderabad, Bangalore, and 4 tier 2 cities, which is Mangalore, Mysore, and Belgaum. The Shimoga Center will formally sign its first incubatees on Monday. So there are 3 incubatees that we will sign up on Monday. There have been some delays because of COVID-19, etc., but Shimoga is our newest center. We work closely with different funding agencies, USAID, the Bill and Melinda Gates Foundation, UK Aid, in the government, the Department of Science and Technology, Department of Biotechnology, and BIRAC to channel funding to startups. This is how we have a very large portfolio of companies that we have supported. IKP EDEN, while IKP Hyderabad is heavily focused on biotech, life sciences, and agriculture research, IKP EDEN is focused on engineering, product design, and development. So you can literally build, make anything. You can think of it as an advanced maker space where you can literally do metalworking, woodworking, electronics. We also have a small biotech chemistry lab. And apart from all of this, we have multiple funding programs and mentorship programs, which is open to startups across the country. Just to give you a quick snapshot, we have supported over 600 companies. We are now in 7 cities, 9 centers across these 7 cities. We have been directly responsible for creating over 10,000 jobs, R&D jobs, and each of these R&D jobs translate to other tertiary jobs in manufacturing and in tertiary services. Right? We have a plethora of funding programs open. So we have Nidhi Prayas, which is a 10 lakh grant. This is for product development and prototyping. So if you're a hardware product startup, you should be applying for Nidhi Prayas. Biotechnology Ignition Grant is the flagship program of BIRAC. The deadline is September 15th, 2020. Please do get in touch with us if you're working on a life science or agri or biotech or healthcare product. Right. We also manage investment programs where we invest in the startups, and that is the theme behind this webinar, which is how do you keep yourself ready at all times for investment. We have the LEAP Fund program and the Seed Fund program that is open again to life sciences, healthcare, agri-tech startups. With that, I will request Ms. Dipanvita Chattopadhyay to say a few words on corporate governance and the importance of staying ready for investment.
Thank you, Vikraman. So it's a great pleasure for me to welcome Anantram Ganesh. Anand, thank you for joining us today as the lead speaker. And of course, welcome to all the participants of the webinar. I know actually Friday afternoon, there's at least 25 webinars, if not more, running in India. I have invitations for maybe about 7 or 8 of them. It is difficult for all of you to select which one to go to. In many of the webinars, I know like some of our startups like Niramay, Geeta is speaking at Mumbai Sign today as we are doing this webinar here. So if you have cared to join the webinar here today, it means that either you are a startup or you are an incubator or somebody who's really interested in understanding corporate governance and how that would help you take your company forward. You may not be an entrepreneur as yet, but at least you want to understand what entrepreneurship and formation of a venture is all about. You know, Vikraman asked me to just say what corporate governance is. The name says it all, actually. It's about how a company is governed, how a corporation is governed. It's a set of policies and guidelines or rules maybe that determine how a company is directed, what kind of decisions, strategic or may not be strategic decisions, can be taken by what level of managers, which decisions must be decided by the board of directors, what kind of decisions are taken by the shareholders. You have to understand the difference between executive, board and shareholder. I think if as a founder for a company, if you understand the difference between executive who run the company, the board who governs the company, and the shareholders who actually are members, who put in money in the company, and what are the different kinds of governance principles that would guide these three buckets of people, if I may say so. Yes, of course, you have to take care of your customers, governance because of that. You have to take care of your external funders, the government, and the regulatory system around your local government and the central government. All these are very important. Some of the rules and guidelines of the corporate governance would be as per the Companies Act. Some would be Ministry of Corporate Affairs. Some would be as part of your articles. That also you need to understand the difference between your memorandum of articles, your articles of association. So I think memorandum of association and articles of association, you really need to understand what's in it and which ones are absolutely essential to be followed as per Companies Act, as per the state government rules and regulations, as per the central government, the federal rules. So it also depends upon which sector you are in. And yeah, I would love to hear Anantram. Vikraman?
Yes, so before we get into Anantram's presentation, yesterday the Global Innovation Index report came out and India broke into the top 50 for the first time. As the chairman of IKP running the large incubators and also having authored a chapter in that report, can you give us your thoughts?
Thank you. The Global Innovation Index, this is the 13th edition of the GII. It's an international report that looks at 131 countries in terms of ranking them on various indices of innovation. There are 80 indicators. Many of them are called input indicators, some are called output indicators. All of these are kind of used as weights and an overall ranking given. Ranking is given for economies, countries, that is, and also for clusters. I have to tell you that India I remember in, I think, 2014, our rank was 81. And in 2020, our rank is 48. And it is not that only India is vying to be into the top 20. All countries are kind of trying to see that they really do well in terms of innovation, because in this knowledge economy, in this millennium, we know that the currency is knowledge. The currency actually is innovation. And if you have to survive as a country, as a region, as a company, as an individual, you really need to look at the differentiation, and that differentiation can be done through innovation. So out of the 3 clusters that you can look at, the top 100 clusters, we have Bangalore, Delhi, and Mumbai have figured in the top 100 clusters across the world. If you look at the startup Blink report, Hyderabad, Chennai, and Pune also figure. So we have to see how we transition from a startup economy to an innovation economy. That itself means that we have to really look at where our differentiation is. We are the 3rd largest startup economy, but we are ranked in the innovation index as the 48th. Hopefully, with all the right policies and all the right startups, we should be able to improve even in this kind of a pandemic situation. Let's hope for the best. And thank you, Vikraman. All of you can go and read the India chapter. It kind of gives you a glimpse of how the economy is moving and what's happening. The topic for this year was who will finance innovation. It's very direct. Who will finance innovation? Is it the VCs? Is it the government? Are there other philanthropy bodies that are going to finance innovation? For India, there's a chapter that I had the honor and privilege to author. So love to get your feedback whenever you want to. Send it to IKP. I'll be happy to reply. Thank you. Thank you, Vikraman.
Yeah, thank you so much, ma'am. So to everyone, we keep hearing about how Indian companies have to move to the US or move to Singapore. You have to flip, and investors will not come in unless you flip to a US entity or a Singapore entity. You may say that ease of doing business is easier in the US, etc. But it's also the responsibility of startups and innovators to be ethically correct and follow proper governance. So that we can stay in India and not have to flip every time, and we can attract international investment. So 81 to 48 we have managed to achieve. I think we need to get into the top 10. So with that emphasis on governance, I hand it over to Anant Ram. Anant, I've made you the host of the webinar, so over to you.
Thank you very much. Thank you very much, Vikraman. Thank you, Deepanvita ma'am. Thank you for that wonderful lead into the presentation. I think it was very appropriate what you said. Let me first of all start off by saying that, when we look at corporate governance, right? What am I going to focus on in this presentation? I am focusing on purely from a company perspective, because mostly investors that are looking to invest in a startup in India are looking at investing into that structure. And that structure is a private limited company on account of a few reasons. One is that private limited company has actual shares, so I have instruments, and therefore, sure, go on, Vikraman.
Anant, I think it's buffering. I don't know if I'm the only one facing that problem. Your video is buffering a bit and voice is not clear, is what Vishu says, voice is cracking. If you could disable your video and just speak. Because
sure,
the presentation is out there anyway.
Is this better?
Yes, this is much better. Yeah.
Okay, so I was saying that the focus of this presentation is on corporate governance from a company's perspective. And the reason I'm doing that is because investors in India, they prefer to invest in a startup that is a private limited company. I think that is the reason that the focus is this, because if 9 out of 10 startups, or actually it's 99 out of 100 startups that are invested in India are usually private limited companies. Having said this, let me move on to the presentation itself. I think corporate compliance is a very important part of corporate governance of a startup itself. Now, why are we looking at corporate compliance? because an investor wants to know how well a company is actually geared for its
Can you
investments
also
itself.
go full screen? Sorry to interrupt. Can you Control L takes you to full screen?
Sure. I was saying that investors want to know that a company is compliant with actual company law and the corporate compliance requirements that are prescribed there. Now, what are the most important ones that you would usually look at an investor focusing on? And this is basically from all of my experience of working with investors and the way they evaluate startups and the corporate compliance in a startup. The first thing, of course, that investors look at are the charter documents of a startup. What are the things that we would usually look for in the charter documents? Is that, the charter documents must demonstrate that there's an actual understanding between the co-founders of a company on how they plan to run the company. So the founders have a certain agreement on, how they will govern what part of the business. And that is something that is very important. And the reason that it's important to figure in the charter documents is that the charter documents are the bylaws of a company. It is the set of rules that a company has to abide by while carrying out its business. So therefore, investors are very, very keen on ensuring that if there is an agreement between the founders, or that there is actually an agreement between the founders in the way that the company has to run in an organized manner. The next thing which investors look for is if there's actual necessary headroom to issue, shares or CCPS or whatever instrument that an investor is looking to actually acquire by making an investment in the company. Of course, I will get into the instruments in greater detail in the second half of this presentation, but the reason that they look at this is because a company has a certain fixed share capital, and therefore the charter documents have to enable you to either make the investment or increase your share capital so you can make the investment. Another few things that are important in charter documents itself is that, the charter documents have to be enabling for you to actually expand. So the charter documents must allow you to, conduct whatever business you're conducting the way you want to. The second thing is that the charter documents must allow you to issue all kinds of securities that you want to actually issue to your investors. So for instance, suppose you're looking to issue preference shares to an investor, your charter documents must be enabling for you to be able to do so. Another set of issues that we usually come across are corporate actions, right? So we know that founders are, the ones that are driving the business of a startup, and they don't really, at least when the startups that I have evaluated, a lot of the startups don't really hold uh, board meetings or carry out the necessary corporate actions to enter into their agreements, for example. Now, why is this important? The company's law is very clear that, suppose a company is entering into an agreement, the company is only bound by that agreement provided the person signing the document has the authority to sign that document, right? That is one of the most important things. Another thing is that board meetings have to be held at least 4 times a year with not more than 120 days gap between board meetings. That is something that is very, very important as a compliance under the Companies Act. Another thing that comes to mind is that, when you're holding a board meeting, you have to actually have sent notice to the directors. It's a formal notice. There's at least 7 days notice. If the notice is lower than 7 days, then there's certain approvals that you have to get from the board of directors to actually hold a board meeting at shorter notice. Similarly, every year a company is required to hold at least one shareholder meeting. So that is a very, very basic corporate action that, a startup has to ensure that it has complied with. Another thing is when you say passing appropriate resolutions, startup founders tend to, have discussions off the cuff, and then, that's how they make decisions for the company's business. It is very important from an investor perspective that, if there is a requirement under law that you actually pass a resolution for some action of the company, then that resolution is duly passed. So for example, suppose a founder says that, let's start granting ESOPs to our employees, for instance. There is a requirement under law that you hold an actual board meeting, you uh, decide to, adopt an ESOP plan, then the shareholders of the company pass a shareholders meeting, accepting that the ESOP plan will be implemented by the company. So these are necessary corporate actions without which, this decision of the founder isn't really valid under law. So that is why this becomes a very sort of important thing that founders have to keep in mind. Another thing is having a core board or shareholders meeting. Now, what I have seen is that a lot of founders tend to have, family and friends also on the board rather than just the co-founders themselves. So there might be a board where the strength is 8 directors, and there are board meetings that are held with 2 directors. Now, the law says that, a board meeting has to have at least 1/3 of the board present for the board meeting to be valid under law. So this is something that, startups need to keep in mind. A is keep your board extremely slim, keep only people that are actually deciding matters and going to attend board meetings on the board of the company. The second is to make sure that even if the board is slightly larger, that all of your board meetings have the necessary number of people to come and attend it so that it's valid under law. Same thing for shareholders meetings. The shareholders meetings require at least 2 people, but to attend it physically, and therefore that is a requirement that has to be complied with every time because it is a meeting. Another thing is that you cannot hold board or shareholder meetings on the phone. If you're holding board or shareholder meetings like right now, a lot of companies are looking to do by video conferencing, there are specific requirements under law. There are compliance requirements on how you have to hold an online meeting for board and shareholders. And I think that those are actions that you have to carry out in compliance with the law. And that is the requirement that investors generally look for, because you want all of the decisions to actually be valid while you're entering into a company, because you don't want that sort of uncertainty of how, suppose there's an action that is not taken validly, whether the counterparty can renege. So there's no certainty unless action is taken in a valid manner. This is a very big concern that investors usually have. Another thing which I think is extremely important are filings that you have to make with the Ministry of Corporate Affairs. Now, there are lots of events that happen during the decision-making process while you're carrying out business in a startup. For instance, suppose you're allotting shares to somebody who's put in money into the company. You have to make a filing, in fact, with the Ministry of Corporate Affairs so that the records of the company are up to date with the Ministry of Corporate Affairs. In fact, the Companies Act has a specific requirement saying that if you've done a private placement of shares, unless you make this filing, you're not even allowed to touch the money. And I know that a lot of startups are always they needed the money yesterday, right? When you're raising funds, you needed the money yesterday, whether it's from family or from your friends. And you touch the money as soon as it hits your account. But have you actually made the filing? Because otherwise there's a big penalty under the law and you're actually non-compliant. And investors do not want to take any sort of risk on a company that is not making its filings on day one, because it exposes you to such sort of penalties. Another thing which is very important is that suppose you've appointed someone as a director, right? You need to make an actual filing with the Ministry of Corporate Affairs reflecting that person as a director. That is an extremely important filing. Similarly, I mean, startups have a lot of flux. So suppose a director of the company resigns and leaves the company, there's a need for the company to actually make a filing to record the resignation of the director so that the Ministry of Corporate Affairs website is up to date. And this actually also goes back to, affecting the quorum of a board meeting. So for instance, suppose you've had 8 directors come and go in the past 8 years, and you actually have only 3 directors now, and you haven't done your filings. You have 8 directors on the board. And so you will need to have all 3 directors necessarily present for every board meeting, which is actually inconvenient, because if you had 3 directors, any 2 of them could actually hold a board meeting. Another one is special resolutions. So the Companies Act has a specific requirement for special resolutions, which means that it requires a 3/4 majority of the shareholders of the company to actually vote for a particular matter. And where does a special resolution usually come into play? Suppose you're bringing in an investor and you're doing a private placement, right? Then you might need to pass a special resolution to amend your articles of association and your memorandum of association to increase your share capital. So that is why you will need to pass a special resolution. And you have to file these resolutions with the Ministry of Corporate Affairs, because otherwise your charter documents do not have the effect of being amended until you've actually filed it. Another thing that a lot of startups tend to mess up or delay is, actually making their annual filings. There are very simple requirements for an annual filing. Is that there is an annual report containing the financials and a report from the board of directors on how the company's performed in the past year. This is required to actually be approved by the board and then by the shareholders, and then you have to make a filing with the Ministry of Corporate Affairs. And this is something that invariably, because it's a once a year sort of requirement, seems to fall off the radar and gets missed. Similarly, there's an annual return filing requirement, which is effectively a summary of what are the changes that have taken place in the company from the previous year that you have to file with the registrar of companies and the Ministry of Corporate Affairs. So it's very important that you make these two filings. It's simple, it's two filings, it's once a year, and it's something that I think startups need to make sure that they're doing, so that everything is clean. Because once you make this filing, the records of your company are up to date, your filings are up to date, and it's a very sort of clean record on the registry of that is maintained by the Ministry of Corporate Affairs. Now, there are a few other corporate compliances which I invariably see while I'm representing an investor and diligencing a startup that is not really maintained. Is that, first of all, startups don't have a register of members. The register of members is basically a register which lists out every person that is actually holding shares in the company. Similarly, there's a statutory requirement to maintain a register of share transfers, where every share transfer is actually mapped into the register. Similarly, there's a register of directors and key management personnel of the company, where if there's a director who's appointed or a director who's resigned, it's supposed to be entered into a register. Similarly, there's a register of transactions in which directors are interested, for instance. All of these registers are something where an entry has to be made, and this has to be done as and when that transaction is done. And it's very, and the purpose behind these statutory registers, if someone just comes and wants to inspect the company's corporate standing, A, they go to the Ministry of Corporate Affairs, or B, they just come and take a look at your statutory registers. And if they're up to date, it should give you a very good picture of, how the share capital of the company is, who the directors of the company are, and how the management of the company has been taking place. Now, there's another thing which I have seen, which I touched upon earlier, was use of company proceeds. And a couple of things I think here that are very critical for you guys as startups to note is that, suppose you received investment from anyone, from friends and family, from an angel investor, right? And you've not made your filing with the Ministry of Corporate Affairs. Please do not touch the investment proceeds. There is a fine. The fine can be up to 2 crore rupees, and that is the maximum, of course. It's 2 crore rupees or the investment amount itself. So please do not risk this, because an investor that comes in and sees that you have not actually made your filing and you've touched the money that you receive by investment before making the filing will be very apprehensive to step into a company where there's this risk of liability in the first place. Another thing I think which a lot of startups tend to do, and it's inevitable really, but it is not permitted under law, is suppose the startup has one of the founders as a director. The director needed money. The company loans money to the director. And that is something that is a strict no. It's clearly prohibited under the Companies Act. And the government has been very clever in drafting this provision so that you can't circumvent it by giving the loan to, say, the wife of the founder or the sibling of the founder, or any company in which the wife or the sibling of the founder or a parent of the founder have any sort of interest. I think this is something that is very important, and this is something that's usually quite common that you see across startups. I think now I will move on to regulatory compliance, which is also something that investors view very critically. As a startup, I think one of the things is that while you have a great business plan, it's very important to have visibility on what the legal framework is. I know a lot of startups probably fly under the regulatory radar, but at a minimum, I think it's extremely critical to assess what sort of legal framework applies to you. So there may not be something extremely specific, but there are a lot of broad laws in India. Given the nature of state that we are in, we have a lot of laws, and you have to just ensure that if there is something that is a requirement for you to comply with, then you've actually complied with it. So please take a step to assess what sort of laws apply to you. And I think one more thing that's very important for founders is that given that you're carrying out a business in a particular sector, and I'll just give you an example of, say, because we are in a data economy right now, big thing, which is the new form of currency. And really, not really just the next oil, but because it's unlimited data. Data is supposed to be the uh, new renewable source of fuel, if I may, is that, there's a lot of laws right now, there's a lot of discussions that are happening on regulating data businesses, which is businesses that collect data and use data. So I think you need to be very, very vigilant of what is the new legal framework that's possibly about to come, and just prepare yourself so that you don't have to take a lot of steps to be compliant or incur a lot of cost to be compliant with a new law coming into force. Now, I just thought I'd give you guys a few specific examples of recent laws that will apply to a few startups. For instance, the e-commerce business. There was recently a consumer protection e-commerce rules that have been enacted, uh, and they have certain compliance requirements for your e-commerce business, depending on whether you're a inventory based model or if you're a marketplace model for e-commerce. Of course, these are all nuances that apply, that are extremely specific to the business activity you're undertaking. But this is something you ought to be aware of, and you ought to prepare for. If there is a law that is not in force today, but that is impending, it's best to be prepared for it. Uh, the other thing that a lot of startups tend to ignore is labor law, because it is something that they would rather focus on once they have a lot more employees. But please understand that it's extremely critical to follow majority labor laws, because otherwise there is a possibility of the labor inspector coming and shutting down your work premises and creating a lot of nuisance for you. Now, some of this labor laws that you ought to comply with, obviously, is, payment of provident fund to your employees, complying with whatever is the prescription for working hours, leaves, and conditions of service. Please always have a sexual harassment policy, and please comply with whatever health and safety norms that are applicable to your specific set of operations. I think these are very, very important things that one has to take into consideration. Now, once all of these are done, now there's one obvious last set of laws in India, which are local laws. They're obviously very, very state specific. They range from having to take trade licenses to shops and establishment registration. The shops and establishment registration, in fact, even contains conditions of how much notice you have to give your employees while you're terminating them. Some of them say you need to give 15 days notice, 30 days notice, 2 months notice. This is something you need to comply with. There's also a lot of regulations that are very, very state specific, revolving around fire safety. For instance, you need a NOC from the municipality, the local municipal authority, if your building exceeds a certain height in Karnataka. That's something that you need to take into account. And again, this is very, very specific to the activities that you're undertaking and your business establishment itself. Now, another thing that I thought which is very important is the business operation conditions. Of course, a lot of founders like to focus only on the business, and that's the only sole thing that they focus on. And even there, I think in startups, while an investor is looking to invest, there are certain key things that they would like a founder to focus on. For instance, the one thing that is most important from a business perspective is the intellectual property rights. If there's something unique about your business, if there's something that is proprietary about your business, investors want to ensure that such proprietary rights are solely with the startup in which they're investing. They don't want the rights to be with the founder. They don't want it to be with a holding company. They don't want it to be with any third parties. Now, why am I saying third parties? There are many instances where, a startup might commission, say, a software to be developed for them from a freelancer. We are in a gig economy, right? And there is really not much of paperwork between them. I think it's one thing to do that, and the other is that an investor that takes a look at it will insist that there's some sort of written documentation. At the time of investment, the condition that I will tell you, I have seen investors insist on, is that the founder actually go back, trace the developer who might be an individual sitting in Bangalore today and he's moved to Bombay tomorrow or Delhi uh, day after tomorrow. And you have to trace that person down and get a written confirmation from him that whatever software he's developed for you and that you own that software. It's better to, from an efficiency perspective, that if you're entering into a commercial relationship where you're paying someone to develop software for you or develop your IP for you, a marketing campaign, for instance, that they just sign over all of the intellectual property in whatever they're developing for you to you. You've paid for it. Another thing that I've seen is something that I think is fairly common, is that, there's a lot of startups use unlicensed or pirated software. I mean, this is something where you just have to drop a little bit of money, and depending on how critical it is for your business, please spend that money to get a necessary software license. Please don't obtain a personal license, please obtain a business license, because the terms of a business license are what will apply to a startup that is carrying out a business activity. Uh, that is something that investors are very, very, very particular about, because if someone slaps an infringement notice on you, and then they can claim a lot of damages from you. Now, from a business contracts perspective, there are a lot of business contracts when it comes to a startup which are not written. So, for instance, in the business, the way an investor evaluates it is what are the contracts with the vendors of a startup or the service providers of a startup. Someone who's supplying me goods, someone who's giving me a space to keep my office in, someone's giving me a warehouse space, for instance, and who is my customer. So it's very essential to actually have in writing business contracts for a startup. Sure, word of mouth is something that a lot of founders tend to do, and it's probably because of the faith you've had with someone you're interacting for a long time. But from an investor's perspective, he wants to understand what the terms are, and it is not very clear what the terms are unless you have it in writing. Now, another issue that we usually see is that, while startups might have entered into a contract, they are unstamped contracts. Now, why am I focusing on a contract not being stamped? Because if a document is not stamped, and suppose there is a dispute, say tomorrow, between the parties to that contract cannot be admitted as evidence in a court of law. An investor wants to ensure that, if there is a dispute situation, any contract under which the startup is trying to claim money is actually admitted as evidence. So this is something that might seem like a very small, trivial issue, but it is something that investors do pay a close amount of attention to. Another thing that is very, very common is that, while startups enter into a contract, they'll say this is a contract that is for a term of 1 year, and then no one's really keeping track of when the contract expires. So obviously there is a need for startups to either monitor the contract until when it's due for renewal. The other more simple thing is for the contract to just simply provide that, the contract is valid until it is terminated in writing by both of the parties. So this is something that, will not necessitate re-execution of contracts or renegotiations over and over again. Uh, Now, what is also important in a business contract is that it is very clear. It is very clear what each party is doing. So what the startup is going to do, what its obligation is, if it's with its customer, you make sure that you're writing down exactly what you're supposed to provide. and what your rights are. So for instance, the payment. One is, it's not just important to talk about what is your payment that the startup will receive, but also the terms of payment, about the invoicing, whether the payment can be disputed or not disputed, and on what grounds. It's very, very important to say that. There's also a very, very important requirement of ensuring that, a startup does not say, I will just pay you for whatever damages you incur under a contract to their customers, or for a startup to not have a recourse to actually claim indemnity, which is compensation for the loss suffered by the startup if a vendor of the startup breaches a contract. And then from a startup perspective, obviously, it's very important to limit your liability. So please ensure that you have a contract which limits your liability to a finite amount, because investors do get jittery if they see that your liability of a startup is open-ended. Another thing that's important for a startup is to have a right to terminate contracts. Now, why is this important? Because after a certain point in time, a contract may not really be feasible for the startup to service, right? Or there might be, for instance, in COVID times, right? There are many contracts that you've entered into where you have an obligation to pay money, and you don't have a right to terminate that contract on account of COVID. So it's very important for the contracts to be balanced in a sense that the startup at least always has a right to terminate it for reasons that its business operations are not able to afford that contract. And that's something that, everyone ought to keep in mind. Now, another thing that is fairly common is related party transactions. Investors look at this very, very closely. It's they don't want any leakage of money from a company. And the things that they look at are that related party transactions are only done if required. Now, what is a related party transaction? Let me just take a step back. A related party transaction is, say, a transaction between a company, a startup, and another company in which a co-founder or his relative has some sort of interest in, right? So this is the way that, many times startups are structured, because I might start a business which is complementary to a family business, right? So there can be related party transactions of a startup with related parties. And then the rules that an investor usually looks at is that they are absolutely necessary for the startup. There are clear written terms. It is not a word of mouth, or it is not an oral contract. The contract is on an arm's length, meaning that if you were to enter into the contract for the same services or for the same purpose with a person who's not a related party, you would have substantially the same terms, both commercially as well as from a legal perspective. And that also, the startup has a right to terminate the related party transaction, which is kind of connected also to the business contract, that the startup always has a right to terminate that contract. Now, I think another important thing is employee agreements. Now, a lot of people wonder, why will an investor care about the employee agreements for the employees of a startup? They want to understand who the key employees of the startup are, and therefore there should be a clear description of the roles and responsibilities. Another thing is that, a lot of employees will develop intellectual property, and the employee agreement should contain a provision that all such intellectual property belongs to the company. This is connected with the other business consideration of all intellectual property, say from a third party or from a vendor, belongs to the company. The founder's intellectual property belongs to the company. And because that is where it captures value for an investor, that the startup has all of the intellectual property in connection with its business. Another very important thing is that, employee agreements have non-compete and non-solicitation provisions. What are these? A non-compete provision essentially says that while an employee is working with you, he does not carry out the same business by himself for himself. Another is a non-solicitation provision, that an employee will not cause other employees to leave your company once he leaves it. He will not try to solicit customers of the company away from it, once he ceases to be an employee of the company. I think this ends part one of my presentation, and happy to hear if you guys have any questions or thoughts.
Hi, Anand. So the first question that came up, can we use the initial capital that we infuse into the startup for daily operations?
Yes, you can, because the initial capital of a company, which is pursuant to your subscription to the memorandum and articles, there's no filing requirement additionally. So of course you can use the initial capital that you've infused into your startup.
Right. What when a fund raised through family, friends, and founders themselves is minimal, which is non-taxable, example 3 to 4 lakh rupees, is this also uncompromisable?
So when I'm saying you're raising funds by way of private placement, it doesn't have any sort of monetary threshold. If you're raising it from friends and family and they're not already shareholders of your company and you're doing a private placement, then of course you cannot touch that money unless you make your filings.
Okay. Can we keep a pool for investors and a pool for ESOPs right at the start of forming the organization with a proper founders agreement?
Sure, it is possible. Of course, you can, provide for a pool for ESOPs. I'm not really sure what you mean by a founders pool. I'm guessing you mean a pool for advisory shares. I'm not very sure, but
Pool
if
for
it is advice,
ESOPs, yeah, pool for ESOPs and pool for investors.
when they say pool for investors, I'm not really sure what they mean by pool for investors. But of course, you can allow for enough authorized capital so you can invest, allot shares to investors.
Are there any leeways or benefits given during this COVID-19 time in terms of delays in filing or any other benefits that are being given at this time?
There is some scheme that was going on by the Ministry of Corporate Affairs, I think, which ends on September 30th, where if there are certain delayed filings that are identified, you can file it without paying a late fee. However, if there is a contravention of the law, for instance, like I said, a company using money that it has received without making the filing for the share allotment, that is something that is not forgiven on account of COVID-19.
So what can you give examples of what are absolute no-nos for an investor?
From a filing perspective, from absolute no-nos for an investor from a filing perspective.
From any perspective, I guess. So the question is fairly broad.
Sure,
Yeah.
sure. So I think then absolute no-nos for an investor is that, the startup is paying money, it's leaking money outside of the startup to all of the founders and their relatives without any need. So money is being taken out of the startup. Uh, the other no-no is that, the startup itself is not carrying on all of the business across jurisdictions. So for instance, a founder has a startup in India and he sets up a startup in Sri Lanka, but which is carrying out the same business, but the startup is not under the Indian startup. It is not a subsidiary. So the revenue is not being captured in India under the larger umbrella of the startup in which the investor is investing in. That is an absolute no-no. The other thing is, suppose a promoter of a company looks to invest in the share of the company below the value in which an investor would be coming in. And that is something, suppose I was investing today at 10 rupees a share before my investor comes in tomorrow at 20,000 rupees a share. And it is within a finite time period of say 3 to 6 months, unless something has changed which affects the valuation. If a promoter puts in money at lower valuation than the investor itself, is something that I have seen investors have raised a lot of concerns on.
Is there a portal where we can check our concerns? what would be a go-to website or a go-to repository of information, which
So
is
Judge,
probably easy to digest for a startup or a founder?
there is the Startup India website which talks about all of the exemptions that are given to a startup. Apart from that, the Ministry of Corporate Affairs also has a lot of FAQs. Of course, they won't be as comprehensive as if you had to go to a lawyer, because a lot of questions are extremely specific to your context. So these FAQs aren't really geared towards that. Uh, but otherwise, you can go to the Ministry of Corporate Affairs website where there are FAQs under companies law, and you can go to the website of Startup India.
Okay. So I guess those are the questions that we have at halftime. So there's one more question. If an employee breaches the IP filing before leaving the company and makes some changes to the idea and starts his own, can that be punishable? Yes, that is punishable. All right. So yeah, I think that brings us to the end of the questions for part one. So
Sure.
I'll start compiling the set of questions once your second half of the presentation is done.
Sure. Right. Can you guys see my screen?
Yes, we can.
Sure. So I think the second part of the presentation, what I'll be focusing on is the relationship between co-founders and investment instruments. So let me move on to that. First thing I'm going to focus on is a founders agreement. Now, what is a founders agreement? It's an agreement where the founders define their relationship. When I say define their relationship, it basically is a reference to what each founder brings to the table for the business and operations of a startup. Now, what is usually also done in a founders agreement is that you provide a framework of how the corporate governance of the startup will take place. So, for instance, you will talk about how many board meetings will happen in a year, how many shareholder meetings will happen in a year, what sort of advisory board you will have, what sort of decision making process you will have, and these become important provisions. So the important provisions are obviously that what the founders' roles and responsibilities are. Now, the founders' roles and responsibilities, it is always good to put it very clearly and in detail, so that when an investor is looking at your founders agreement before looking to invest in your company, he gets a lot of clarity of the role of each co-founder of the business and what sort of value each co-founder brings. Another thing that is management composition is of two kinds. First is, of course, who the directors of the board are, how many directors of the company will have. Also, it is more of, who are the executive personnel of the company, who all will actually take the business and operational decisions in respect of the company. How will the decisions be taken? Will co-founders take decisions only if they both agree? Or if there are three co-founders, only if they all unanimously agree? Or does one co-founder have the final say on certain aspects? So whether it's a technology, the co-founder that brings the technology to the table versus the co-founder that brings the operational expertise, who takes the decisions on what sort of matters? Another thing that you should very clearly specify is the share capital of the startup. It's very important to clearly define it. You can talk about, there was a question earlier of, suppose you want to keep an ESOP pool, or suppose you want to keep a pool, advisory pool, for people that you will not have as an employee of the company, but you will bring on as an external advisor to the company. Another thing that is very important is for the co-founders to talk about what is their vision on future funding of the company. If the company requires future funds, are you immediately going to an investor first step? Are you looking to go to a bank? Are you looking for the founders to put in money themselves or raise money from friends and family? What sort of funding options are you looking at? Now, are you also looking at share transfer restrictions? Now, what happens is a lot of founders enter into a company and then they want to give their shares away to uh, they want to just get out of the company, so they sell their shares, for instance. Are there share transfer restrictions preventing that? And why an investor will take a look at this very, very closely, apart from also requiring that a founder doesn't transfer his shares, is to understand how much a founder is willing to actually handcuff himself to the company and be bound by the company. So if a founder is very serious about the company, I don't then the investor gets a lot of comfort that he is actually married to the company, and the idea of taking the company to its to all of the heights that it can scale. So that is something that is very important. Another thing a lot of investors talk about is vesting of shares. Now, what exactly is vesting of shares? A vesting of shares is that, a founder agrees that none of his shares will move even to anyone else, including him. And it is effectively a transfer restriction where over 4 years is when all of his shares come back to him and he can transfer it. Of course, I think when you go into a more advanced round of funding rather than remaining at seed funding, uh, uh, founders are not allowed to exit the company unless investors exit the company. Other share transfer restrictions that investors really keen about is that if a founder is looking to get out of the company, then they cannot get out of the company unless the investor gets out of the company. And that if a founder wants to get out of the company and is allowed to by the investor, then the investor has a right to buy the shares or the co-founder has a right to buy the shares, so that there's no one new that you're saddled with in the company that you do not have a working relationship with. Another thing that is important to usually have in your founders agreement are provisions relating to a business plan. Now, what are these provisions? A is that there should be an annual business plan and a 5-year business plan. The second thing is that these business plans are subject to periodic review, whether it's every 6 months or every year, so that you can adjust your business plan depending on how the operations of the startup are actually going on. And this also shows the investor and demonstrates the fact that uh, the startup the founders have a very clear vision for how the business of the startup should go, and they're also agile and they are taking steps depending on how the business is going at every interval that they're reviewing the business plan itself. Another very important thing is a non-compete and non-solicitation. This is even more important for founders than it is for employees. As I touched on earlier, a founder should definitely not compete with the business of the company by himself. A founder is a shareholder of the company, and therefore an investor won't want the founder to get out of the company and then also compete. So therefore, the provision that an investor typically wants a founder to commit to is that if he is as long as he is a shareholder of the startup, and for a period of say 3 or 5 or 7 years after he leaves the startup, he will not compete with the startup. And similarly, he will not solicit clients of the startup, employees of the startup. He will not solicit people that are providing services to the startup or take anything that will result in the startup's business being adversely affected. And there is no conflict of interest between the founders and the startup itself. So these are very, very important provisions that you need to have in a founders agreement. Of course, there are a lot of other provisions as well that you can incorporate in a founders agreement. For instance, you can incorporate provisions on how the profits of the startup will be divided amongst the founders. You can incorporate provisions on what sort of exit you will provide one of the founders if the founder ceases to hold shares. You can provide provisions on whether a founder can restructure his shareholding to hold it in a trust so that he can set up a wealth trust for his successors. But these are all extremely specific to the founders that are involved by themselves. Now, I would like to talk about, what sort of investment instruments a startup can typically expect to issue to an investor. First of all, equity shares. It is the most common instrument. These are the shares that the founder holds themselves. An investor does not typically take equity shares by itself. An equity share is only taken by an investor in a very limited quantity so that they have an entitlement uh, to vote at shareholders meetings of equity shareholders. This is something that is a requirement under law, and therefore investors tend to structure their investment as maybe 5 equity shares and 10,000 other instruments, for example. The other thing that you will typically see investors look at is compulsorily convertible preference shares or debentures. What is a compulsorily convertible preference share? A preference share is a different type of share from an equity share, and the term compulsorily convertible is fairly self-explanatory. It suggests that at a future date, these preference shares will convert into equity shares. Uh, Now, what is a compulsorily convertible debenture? A debenture is a debt instrument. I don't know if a lot of you actually subscribe to these non-convertible debentures that are there in the stock market, where it's a way of raising debt. But the thing is that a compulsorily convertible debenture is only a debt instrument uh, by name, but by nature, upon the time of conversion, it compulsorily converts into equity shares. So it is not a debt that is repayable, but it is a debt that is satisfied when you change your debentures into equity shares of the company. Optionally convertible shares and debentures are different from compulsorily convertible shares and debentures in that an optionally convertible share or a debenture can be redeemed, in the sense that suppose I held 50,000 optionally convertible debentures, I could give them back to you and get back the face value of my instrument. Now, face value is a technical term, but I don't know if many of you are aware, but the face value is what is the basic value of an instrument over and above which you pay a premium. So a share can have a face value of 10 rupees, but if it trades at 150 rupees, then the premium on the share that you're buying it at 150 rupees is 140 rupees. So you can redeem these optionally convertible shares and debentures at their face value. Now the last and most I think hot topic now is for a startup to issue convertible notes. Now, convertible notes are not an instrument at all, in the sense that they are not, you will not get a share certificate or a debenture certificate for a convertible note. It is effectively just a loan that is given to you, which an investor may convert into equity shares, or he may uh, ask you to actually repay with a certain amount of interest. Uh, I think I will do a comparative overview in the next slide of all of these instruments that I've just explained to you. The first thing, like I said, is the nature of these instruments. Equity shares, compulsorily convertible preference shares are both purely equity instruments, in the sense that they give you a direct right to, in the share capital of the company, to be a owner of the company. An optionally convertible preference share, which is an OCPS, is an equity and debt instrument, in the sense that until you actually exercise your option of converting it into shares, it does not really affect the cap table of the company. The way it affects the cap table is a very technical way, in that if your memorandum of association has an authorized share capital, the OCPS are considered a part of that, but they do not translate into equity interest in the company until you actually convert them. Once they are redeemed, they have no more effect on the share capital table because they are repaid. Compulsorily convertible debentures do not affect your authorized share capital on day one, and they are quasi debt because they're not really debt instruments. They contain a very, very nominal sort of interest payment, and even which may not be repayable in cash. So it may have a 0.001% interest rate on a compulsorily convertible debenture, and they convert at the time of their conversion is when they actually have an impact on the share capital. Optionally convertible debentures are again a debt instrument because you have a right to seek its repayment. But if the investor actually exercises his right to convert it into shares, then it becomes an equity instrument, and therefore it impacts your share capital only at the time of conversion. A convertible note, like I explained previously, is a loan which is convertible to equity at the instance of the investor itself. The impact on the share capital is only at the time of conversion. Now, something that is important to note is also, what is the valuation or the issue price for these instruments and how they are distinct. Uh, for equity shares, obviously, there is a fixed valuation, and therefore the issue price is determined upfront. When it comes to compulsory convertible preference shares and debentures and optionally convertible preference shares and debentures, usually investors and promoters or founders determine the valuation upfront, and there is a formula and there are certain assumptions of the way the business of the company will scale up, and that is the basis on which the shares, the optionally convertible preference shares or compulsorily convertible preference shares or debentures for that matter actually convert. Now, for convertible notes, the interesting thing is that you don't have to agree on a valuation upfront. In fact, invariably, you issue convertible notes when the founder and the investor are unable to agree on a valuation. So therefore, an investor is willing to say put an X amount of money in the company. I will just throw a number out there for illustration. Suppose an investor wants to put 10 crore rupees in a company, and he's saying he wants to value the company at 50 crores post money, meaning he'll have 20% of the share capital, and the promoter disagrees and thinks that the 10 crores should only give the investor 10%. Then what they do is they issue a convertible note for 10 crore rupees, where you will specifically say that there are certain parameters, operational parameters of the business, financial parameters of the business. Once they are achieved, so it's effectively, if they are achieved, then the valuation will be closer to what the founder wants it to be. And if it is not, the valuation will be closer to what the investor wants it to be. Another thing that a convertible note typically does, if it is not this, is that where a valuation is not determinable on day one, the investor will put the money in and say that the valuation at which shares should be issued in exchange for the convertible note is a discount to the next round of fundraising by the company. So for instance, the investor puts in 10 crore rupees and says, I want a 20% discount on the valuation of your Series A round, for example, or your Series B round. Then suppose the Series B round is at 150 crore valuation, then the 10 crore converts at a valuation of say a 10% discount, right? So 135 crores. So that is the upside for the investor who's put in a convertible note. Now, another important thing that you have to take into consideration is the stamp duty. A stamp duty is basically effectively a tax that you pay to the government when you are raising an investment. It is on the instrument that you issue. And I thought that this is something that is very, very important to illustrate to you guys, because it talks about the outflow of funds from the company itself while it is raising an investment. For equity shares, you incur stamp duty upfront on the share certificates that you're issuing. It is based on the valuation of the shares. On CCPS, you incur the stamp duty on the CCPS certificate on day one, as well as on the equity shares that are being issued at the time of conversion. On OCPS, you will again incur stamp duty at the time of issuance, and if they are converted, then at the time of conversion, you again have to pay stamp duty on equity shares. Compulsorily convertible debentures, again, they are instruments. You have to issue a certificate for it, and therefore you will actually incur stamp duty upfront at the time of issuance and again at the time of conversion. Same thing for optionally convertible debentures. That's also the only thing that you are not making an issuance under convertible note. So while you may have to stamp the agreement separately, which is true for all of these instruments, the only time you're paying stamp duty is while you're issuing shares upon the convertible note actually converting into shares. I think these were the things that I wanted to discuss with you in part B. I will now again open the floor to any sort of questions.
Do you need a valuation certificate when you're doing OCPS or CCPS, OCDs or CCDs?
Absolutely, you need a valuation. You need a valuation certificate while you're doing all of this, because the valuation certificate is the basis on which the conversion will actually take place.
Is there a minimum number of shares that you can sell to one person?
The minimum number is one, right? I don't think there is any statutorily prescribed minimum number of shares that you can sell to a person. But the minimum number of shares, I mean, if you look at it practically, is probably one share.
So there are questions on how is valuation calculated and what are the factors to be taken into consideration while valuing a startup?
Right. I think valuation is more a question for a valuer or a chartered accountant, but there are many methods that are prescribed for valuation. One of them is a discounted free cash flow. The other is valuation based on EBITDA multiple. So I think that those are the methods of calculation. But if you want to know what the factors are, I think it's better for you to actually check with a valuer itself.
What are the risks with notes? I'm guessing these are risks for the investor.
Right. So there are risks for both the investor as well as the company with a note. The risk for the investor obviously is that the company goes to zero or it bankrupts itself, and then the entire loan itself is not repayable. But that is something that is true across all instruments. The only thing is that a company will have defaulted on its loan. But why would a investor take a risk on a convertible note? Is that he has an upside for it. There is a corresponding upside if the company does well. The risk for the company is that if an investor wants to just seek that the convertible note be redeemed or repaid at the end, as opposed to you issuing shares to him because he's not happy with the valuation of the next round of investment, then the company is actually going out of pocket for that amount of money. So I think those are the risks associated with the convertible note.
So the next question is convertible notes. Does it favor the investors more than the founders?
It does not really favor one party or another. The thing is that with a convertible note, it is an in-between sort of path, because the investors and founders don't actually agree on a valuation. And while a convertible note is a debt, I think the understanding is very simple that, if the investor and founder can't agree on a valuation, then you find the valuation out at a future date. If the investor is not willing, then then he has a right to seek a repayment of the money. And I think that while you're signing up to that, I think everyone is on commercially the same page, right? So that's not something that should affect one party over another. There's no advantage or disadvantage. It's purely commercial, and it's your discussion and your understanding of it. And everyone's had their eyes open at the time of the convertible note investment. So,
right. So here is a question. So you said when founder and investor cannot agree upon a valuation, you go in for a convertible note. Or does that apply in the case of convertible debentures or CCPS?
no, so in convertible debentures and CCPS, there's a very, very clear requirement that, there's a specific formula, or you agree on a conversion price upfront, right? So the conversion price is determined on a number of parameters, but there is always a minimum sort of valuation. So no investor will ever invest in compulsorily convertible debentures until he knows that the minimum value, the minimum number of shares he's getting is a certain X number. He may get lesser shares if the valuation is better, but he has a floor in mind. He has a minimum valuation in mind.
Okay, there is one question that keeps coming up. I think what they want to do is set aside 25% for the first round of dilution, and they want to set aside 25% for ESOPs and split 50% between the founders. So is that allowed, and how do you enable that?
I think it's a difficult sort of, I think there's a lot of structuring involved around this. It is, when you say you keep a 25% provision for investors, like I'm saying, it's not very clear on what this is. I'm guessing this is very similar to the previous question where you'd asked me the last time around about, having a investor pool and an ESOP pool and then a founder share pool, right? But this is something that's extremely fact specific. Perhaps we could connect offline with whoever this person is and then discuss it in detail. But I think that's possibly something that you can structure, but the structure has to be purely driven by the commercials, and I'll have to understand it to answer that question.
Sure. I guess we'll take one more question. How long, what is the minimum time period between two valuation certificates?
There's no minimum time period between two valuation certificates, but from a practical perspective, what I have seen is, suppose a founder is receiving foreign investment, the RBI is comfortable with a valuation certificate that is not more than 3 months old. But the understanding is very clear that if there is something that changes the valuation of a startup, if there's an event that changes the valuation of a startup, from the date of the previous valuation certificate, it's better to get a new valuation certificate.
All right, I think we are done with our questions. We've asked all of the questions that have come from the attendees. So I think what we can do is request Dipanvita madam to say a few words, and then we can end today's session.
So, Anand, thanks. I think it was very lucid, very nice presentation. You've taken them step by step through the points, and I think the people who are attending today have gained a lot. At least they have understanding of the terms, terminologies, because each subject has its own jargon, set of jargons, and being able to understand and apply the jargons and making it simple, and being able to understand the implications of those words are very important. Somebody said about 25% ESOPs. I think that's very high. Normally, that's because once you keep such a high amount, you have to know that you'll be diluting as you raise. So 25% kept for ESOP seem to me extremely high. What's your comment on that? And why do you need to allocate so much upfront? At what point of time in your company would you actually allocate the ESOP? Anand?
Hi, thanks for that. I was trying to unmute. I was speaking on mute. I think that I'd agree with you. 25% ESOP pool seems extremely high,
Okay.
and it will dilute the co-founders. But I think that what if the right time for an ESOP pool is when you're getting in, just before you're getting in your first big round of investment in the company, whether it's Series A or Series B, just before you're getting your first big round of investment in the company, so that once you give your employees your ESOP, the intention is for them to have an exit and make a lot of money and make hay of all of their commitment that they've done in the company, right? So it's before your first big, say your IPO or your big investment, where an employee can actually liquidate and get a lot of cash. That's the best time to give them an ESOP. Of course, there's a vesting period of a minimum of 1 year, so you'll have to plan accordingly.
Yeah. So always remember there is a vesting period, and of course vesting and then exercising. So both the periods are important. So fantastic. I think Vikraman has taken all the questions. Any one question from anyone else? Otherwise, I'll ask the last question and then we will wrap up. Vikraman, any questions from your side?
No questions from me, no.
Okay. When we discuss it, and then this is kind of an open discussion, and for all the participants to understand, there are certain, we can take examples of companies where it really became very difficult and the founders had to go to jail. If you remember where they could not pay the debts, there's huge amount of, so these are basically, suppose you have some contracts and your business is not working, you've signed up upfront contracts and then your suppliers are coming and so you are a limited you're a limited liability company.
Absolutely. Yeah.
How do you handle your limited liability-ness and avoid getting into these? So which are the ones that would result in criminal liability or would result in suits where the directors land into jail or whatever in court? So how do you protect yourself? What kind of things that founders should look at? And there have been cases like in the last 10 years, a lot of founders had real issues. And it was not really, I would not think they did not understand their business well. So it didn't go well. So, but in a situation like a pandemic today, there will be cases where companies will not be able to keep up their commitments. And there are various kinds of commitments, payment to vendors and so on and so forth. What is the protection if you're a limited liability company? What kind of protections are there?
Sure. I think, thank you for that question. Extremely pertinent. And I think for all of you out there, you've seen Vijay Mallya, you've seen Nirav Modi, all of these folks run abroad because, they've not been able to stand behind their company.
So
they've taken a whole bunch of money.
Vikraman, which one is that? I don't know why I'm missing that name.
Stazilla.
Right. Stazilla. So
Right.
It's not like Vijay Mallya, because our startups will not be able to compare themselves with Vijay Mallya. But
Right.
Something like it started in front of everybody's eyes, and they could not. And it was very sad, I thought. Yeah.
Completely agree. I think principally speaking, completely with you. There are a few things that, a lot of founders of startups do, because they're extremely in their desperation to actually raise funds for the company. So for instance, if you look at an investment agreement, a founder is willing to stand behind the exit for an investor. So he'll say, if I'm not able to get you an exit, or I'm not able to sell my company and get you money, I will buy your shares out for an X amount of money, right? Or I will give you some sort of guarantee on your exit. I will make up a shortfall, suppose you don't make a certain return. Another thing you typically see is that, a founder will give a bank a personal guarantee. Why? And say that, I will sell my assets if the company is not able to repay the loan, for instance. These are some things that, a founder needs to be very, very guarded about, and needs to be careful of, and needs to understand very, very clearly. You have to understand the implications before signing on to a document that someone says, listen, this is a standard document. I think a lot of negotiations involve people saying, this is a standard document, don't bother reading it, just sign it, you'll get the money. And I think you ought to actually be very vigilant. You need to engage the right experts, and you need to understand the risks of what you're doing, what you're getting into, before you actually take on any sort of commitment, especially in your own individual capacity. I think that is something very, very important and critical for founders to take a look at.
Yeah, I think a lot of startups will face issues of not unable to meet their commitments to, especially to vendors, and also vendors may not be able to provide the supplies, and so it's a whole chain that gets affected. And what kind of caution they should actually follow, and it would be prudent for them to follow. Of course, it's a limited liability. So understanding what is meant by limited liability company, I think that is important. It does not mean that you do not have any liabilities. There are reasons and things for which you would land up in court. One thing is taking the DOL. Though I know it's 531, I thought DOL is not touched upon. Directors and employees liability policy. Directors and officers liability policy. So if Anant, you want to talk about it, otherwise what we would do is we may take it up later, discuss all these policies, because it's important for providing directors directors and officers, some kind of protection.
So there's a slight, thank you very much for bringing that up. I was in fact just going to say that, companies should consider obtaining business insurance, which protects them against risks. Directors and officers policy, you're right, is very good for a founder, but it only protects him in the capacity of a director. But if a founder actually signs on to something saying, I'll give you a personal guarantee, typically many vendors will take a bank guarantee from the founder saying that you will honor the company's payment obligations, right? So in those situations, I think you still need to be vigilant, and it's better for the company to get its business insurance policies in place. There are quite a few that are available. Of course, the premiums fairly high depending on how risk, based on the amount of risk that your business offers to the insurer itself. But that is something that certainly companies should consider, founders should consider.
So I think that it's not to scare any of you. It is just because we have to be prudent, and these are going concerns. Remember that we are into the business as a going concern. So we are going to conduct our business as if it's going to go forward. With that, thank you very much. Thanks, Anant. This was great. Thanks, Vikraman. And yes, over to you, Vikraman.
Feedback. It's a very short 2-question poll, so do let us know your feedback.